You're listening to the Business Marketing Show, episode number 76. You can find us at businessmarketingshow.com on iTunes, SoundCloud, and Stitcher. Hi everyone, thanks for listening to the Business Marketing Show. This is Keay-Smith here with my co-host Brendan Tully, and we have a guest on the show today, Guy Provan, who is a solicitor and barrister with Ray's law firm in Australia, one of the biggest independent IP specialists in Australia. And we're going to be talking with Guy about how he got started as a lawyer and what he is working on mainly at the moment, and a bit of a background story. And we're going to be covering how businesses need to protect their intellectual property and covering the areas of that specialty that Guy works in. So thank you very much, Guy, for coming on the podcast.
Good morning, Ed. It's good to be here.
You're welcome. Thanks for taking the time. And as, like me, you are a fellow Scotsman. People will be able to probably pick that up with your accent, but they definitely can't pick it up with my accent.
Once I get going, yes.
Yeah. So thank you. And so your background, because this typically we like to get started in where people have come from to the point that they're at now. You originate from Scotland, and that's where you initially became a solicitor back in 1988. Is that correct?
That's right. Yeah, going back a bit now. Yeah, look, I qualified in Scotland back in 1987-88.
Mm-hmm.
I then moved down to London and spent 3 years working in London for an intellectual property specialist firm there, which was great. You know, the clients of that firm were people like DuPont and 3M and Gillette.
Okay.
Real big names in intellectual property, both in the patents and trademark side of things. So, look, really good 3 years in London, great experience there. But then I moved to Australia in 91 and joined a firm here in Perth, Parker & Parker, which is later merged and was part of Freehills. And then Freehills have since merged, and they're now part of Herbert Smith Freehills, which is an international firm.
Yes.
But I was with Parker's Freehills for, about 10 years.
Fantastic. That would have been a fantastic place to cut your teeth, so to speak, back in Scotland with those large corporations. You would have had a bit of baptism by fire, I can imagine, having to jump in the deep end.
Yes, look, it was great because, you know, there were clients who obviously valued intellectual property and frankly expected to, you know, they knew they were going to have to pay good money to protect their IP and to enforce it. So it was good working for that sort of client. Obviously, very demanding clients. You know, they know what they want and they expect results. But yeah, look, a great baptism, as you say, great place to spend some time learning from people who are, you know, major players in the industry. I had a particular mentor at the firm I worked for in London, who I think helped change me from a pretty raw recruit into a reasonably competent lawyer in the time I was there. So I think it's something which lawyers need during the course of the career is a good mentor to see them develop in their career.
Yeah, absolutely. I think in any career, a mentor is an important factor. So, and Brendan has me, so you know.
Oh, jeez.
Oh, I had to
get this guy.
I had to get that in there. Not true. No, it's the other way around. So, now look, I've got a very important question to ask you, Guy. A very, very serious question. One of my favourite TV shows is Suits. Do you classify yourself to be like Harvey Specter? Do you watch Suits?
Look, I don't watch Suits. In fact, I don't think I've ever watched any of the legal programs like Boston Legal or LA Law. Frankly, I think they would frustrate the hell out of me because
Probably.
they completely misrepresent what being a lawyer is all about.
No doubt. Absolutely.
Sadly, it's not that exciting.
Oh dear. Okay. Well, look.
I'm sorry to disillusion you.
That's all right. I'm still going to think of you as the Harvey Specter of IP law in WA. All right. So that's take that as you will. But so look, in terms of what Brendan and I do, we run internet businesses. We have agencies and we're dealing with customers and clients in all different fields. But one of the things that often comes up is they've got often products or services that they've created and they're putting them out there on the internet, and quite often they haven't got any protection for them in terms of their IP. So this is what we thought, talking to you, you're working with such a great company like Raise, and as a sideline, the reason that I know Guy is Raise very graciously host something in WA called E-Group, which is a technology startup, small business sort of networking support group that meets once a month, and Raise very kindly host that for us at their offices in West Perth. So thank you to Raise for doing that. It's always very nice. And that's how I met Guy, was at this event, and he's there regularly. So there's a lot of companies or businesses who turn up and who are part of E-Group who have this particular scenario. They've created a new product. It could be an app or some piece of software, and they then have the task of protecting that from people stealing it. So where do you come in that regard, and what do you offer people in that scenario?
Sure. Look, there are a number of things which our clients can do to protect themselves in that situation. Sadly, I think most don't really think of IP until after the event, whereas it really should be something you think of up front. If you look at the various IP regimes and how you can protect yourself, the easy one, in a way, is copyright. Because copyright arises automatically. You don't need to register anything. As soon as you create an original copyright work, copyright subsists in that. Mm-hmm. And for example, a computer program is deemed to be a literary work, and therefore it's a copyright work and subject to copyright. So as soon as somebody sits down and does some coding and creates a computer program, they're going to own the copyright in the software. Okay. So that's a good thing.
That's great. Yep.
The downside of that is that the copyright doesn't stop people from copying the idea, the concept. So your app might be, for example in Perth recently, an app for telling surfers that there's sharks in the area, and to obviously stay out of the water if there are sharks around.
Handy.
And there's a guy who kind of developed an app for that, and I think spent quite a bit of money developing the software to do that. And then somebody else came along with a very similar app, which did effectively the same thing. There was no copying of the software. It was really just taking the same idea or a similar idea and doing the same thing. And so copyright didn't provide any protection there. Which then brings you to the next topic, which would be patents. And ultimately, a patent is the only way you can really protect an idea or a concept. So then you have to look at patents and see whether what you've got is something which is patentable. And I think the difficulty here is that, traditionally patents are about products and processes which are much more about, things, three-dimensional things, engineering and things of that nature. Whereas software and apps is really all about intangibles. That said, the law has developed, and particularly the law as to what is patentable has developed. And therefore, there are situations in which, for example, an app might be patentable. Usually it's not just the idea. It's not enough to just have a new idea or a good idea. There actually has to be some step taken in resolving a technical problem before you can get a patent for that sort of thing.
Okay.
But there are attorneys. There are attorneys within arrays, for example, who specialise in patenting for apps or patenting for software products. It is possible, but the requirements are quite strict.
Yeah, and that's the thing. If you're thinking about trying to do any of this sort of stuff yourself, because there are certain portions that people could probably go down the path of registering trademarks and various things, but there are certain aspects of this that require someone who's walked through the minefield before. So if you try and do this yourself, you'll end up blowing your legs off. Poor analogy, but probably the feeling at the end of it all would be similar. So and look, it's one of those. I
think the thing with patents is to make an informed decision.
Yes.
To at least speak to somebody who's got some expertise. And it may be, after half an hour, you realise, no, there's simply no prospect and it's not worth it. But at least you've made an informed decision. And the flip side is that, if there is something there, then you can decide whether or not you want to go down the patenting route.
Okay. And do you typically recommend, when people are going down this path, if it's an Australian-based product, then to me, logically, the first place to start maybe Australia. Maybe I'm wrong with that thought. But then expanding out to the US, the UK, and Europe, I'm assuming that's like a different kettle of fish. Like there's, different aspects of law in different countries that don't equate to the same as Australia. So to cover all that, is that the sort of stuff you'll work on as well with the clients?
Oh, certainly, yeah. The good news is that you can start in Australia. You can put in an application in Australia, and there are various types of application you can make. But the system actually allows you to put in an application in Australia, and then over time, there are procedures by which you can effectively apply in many other different countries. And that can be spread over a 2.5 year period, so that the costs involved are spread over that period. And your application in Australia gives you a priority date by which your priority in other countries is also measured. But ultimately, yes, you have to go to each country and get your patent in that country. So, typically with software type products, clients are looking in the US, in Europe. Those would be the main places, and perhaps some Asian countries as well, like Japan and Korea as well.
Yeah, and then that's a whole other kettle of fish, because you've got the language. You've got to have someone who can, I'm assuming, speak Japanese to deal with Japanese law.
But that's very true. A major expense is getting a patent specification translated into the local language. And often the language of the specification is quite naturally quite technical as well. So you have to get somebody who's not only expert in language, but knows something about the technical side as well to be able to do a translation.
Yeah.
So, the cost of translating can be quite an issue in countries like Japan and Korea.
Yeah, and it would be a shame to end up having a weak point in the patent, etc., due to a language misinterpretation. So, that's an important thing to take care of. So, look, one of the things that Brendan does quite a lot of work with is in the e-commerce space. So, in terms of e-commerce, what sort of services do you provide for that, and what's the most common stuff you work with there?
Sure. Look, I think the main thing, obviously you can get intellectual property protection, but your actual terms and conditions on your website and the terms and conditions by which you sell your product, those are vitally important as well. So if you think of it, it's like there's a portal through which people go to get your product. And at some point during that process, you need to impose your terms and conditions. And in doing so, you can cover off on an awful lot of issues, which puts you into a much better position. Obviously, you deal with IP ownership and things like copying. But you can also look at issues like liability and excluding or limiting liability. So, strongly drafted terms and conditions are pretty important in an e-commerce situation.
Yeah, and I do tend to find that a lot of people will just boilerplate that sort of stuff with websites. I've
Yes.
seen they'll have the same standard templated terms and conditions that they've copied from another site and then just used it across on their site. So,
And often those terms and conditions will be based on American precedents, which are actually not much use in Australia. In Australia, you've got to watch out for the Australian consumer law, which effectively for transactions under $40,000, the ACL will apply, and that imposes consumer guarantees and other provisions which you simply can't contract out of. They're there. You just have to comply with them.
yeah, fair enough. And so if you don't understand that sort of stuff, you can have something that's on your site that's your terms and conditions that really aren't effective at all.
Well, you could end up with provisions which are just unenforceable. To be enforceable, they have to really look at the Australian consumer law and use particular formulas, if you like, which are acceptable under that. But if you don't use those and you just use something from somewhere else, you can end up just with something completely unenforceable.
Yeah, true. So Brendan, seeing as that's an area that we're talking about for you, have you got something you wanted to check with Guy?
Yeah, I've actually got several questions, but you did raise a good point. Can you talk to us a bit more about liability and product liability? Because I know nothing. Like, we had a very big e-commerce store back in the mid 2000s, and I don't think we had any clauses about liability. I assume there might be some default protections businesses have, but tell us a bit more about what are the risks that an e-commerce business is exposed to if they don't have a clause about limited liability.
Yes. Look, I think there's very generally two aspects to that. The first is the liability for the product itself and the performance of that product. And certainly under the Australian consumer law, there are minimum requirements. Like, it has to be of acceptable quality under the ACL. So you have to comply with those provisions. Otherwise, your consumer would have a claim against you for defective goods or defective services. The second aspect is a wider aspect, and perhaps not quite so relevant to e-commerce businesses. And that's where there may be some consequential loss or damage. Look, I remember advising a client who had a laser product. It was a sort of stop your hair falling out, and you basically put this helmet on and had lasers pointing at your head.
Whoa, that sounds
We were going into the Californian market, and the issue of product liability and possibly causing injury to people was a real live issue for them because of what they were doing. Perhaps less so in e-commerce. Although if you think about it, if your product is a safety app for some safety aspect, and then it fails to operate, and as a result somebody suffers injury, then you could be liable for that. Again, you can put yourself in a better position by having terms and conditions which effectively try to deal with that situation.
Yeah, great. And what were the other ones you had, Brendan?
Well, the other one I had, I've been thinking actually a lot lately, and I haven't done anything about it yet, but I should. So some of our products or productized services are quite brandable. So you're going through the process. We've changed our marketing strategy somewhat. And for example, our hosting product, the brand or the name of it's WP Alpha. And we don't have any trademarks. So what, in terms of, registering a trademark, if you don't register a trademark, are there risks around losing a domain name? Do you have any default protection? Could a competitor just go and register it? Because years ago in an old business, we did register the trademarks because, it was more than 10 years ago, so I can't even remember the advice we had, but we were exposed to some risk around losing domain names, and it was the name we had at the time, I think, was Zoom IT, so it was kind of quite generic, and another competitor could have easily come up with it. So can you tell us a bit about that, like a typical small business doing a few $1 million a year? Is there a trademark risk there, or something that, I'm basically asking for myself, what do I need to be aware of in terms of trademark there?
Sure. Look, it is obviously I would say this, but it is a good thing for business, any business, to seek to register the trademarks they're using. Having a registered trademark gives you a number of advantages. It means that you don't need to prove reputation in a particular trademark. If it's on the register, then the test is whether somebody else is using something which is substantially identical or deceptively similar. So yes, there are advantages of getting a trademark registered, and it's a relatively cheap thing to do, particularly if you can do it yourself, which perhaps I'll come to. But the other issue, I think, is, again, the Australian consumer law, which prohibits misleading or deceptive conduct. And often the use of a trademark, if you use somebody else's trademark, it is going to be misleading or deceptive conduct. So even if you don't have a registered trademark, you may be able to rely on misleading or deceptive conduct to effectively enforce your position. That said, you're better to have a registered trademark, because then you can sue for both infringement of the registered trademark and misleading or deceptive conduct and passing off, which puts you in a stronger position. I think another advantage of trademarks, or looking into trademarks, is a defensive and risk management thing as well. It's important to do searches. If you're starting out in business and you're picking your name, you really should look at the register of trademarks to see who else has registered names which might be similar. Because the last thing you want to do is to have your big launch of your product or your services, and then a few weeks later you receive a nasty letter from a lawyer saying that you're infringing somebody else's trademark. So I think, as well as looking to register your own trademark, you need to be looking to make sure that third parties aren't already got something registered, which is going to cause problems.
Mm-hmm. And then what about domain names? So Ed does a lot of domain name investing. So he has, I don't know how many, Ed, you have like thousands, a portfolio of thousands of domain names. So is there, if someone owns a trademark and say Ed they've trademarked, say, a very generic business name, like, I don't know, Dentist Perth or something like that, for example, that's pretty much generic, but Ed owns the domain name for that. Is there, if you hold the trademark for it, could I come along and bully Ed to handing it over legally? Or where does he stand with that? Because I'd imagine that would be a big, some of those domain names in the right hands are worth thousands, millions potentially. Yes. So, yeah.
Yeah, like it's a tricky area, and there is an overlap with trademarks as well. I think the starting point is probably looking at the terms and conditions by which you can register a domain name with the various domain name companies. They have detailed requirements of what you can and cannot register. And having a registered trademark, for example, gives you a good basis to then get your domain name. But sort of further down the list of things which the domain name companies look for is some actual connection between the domain name and your business. And that's how people can get, if you like, the generic names like, dentist, perth.com.au or something like that, if they're actually a dentist. So there is some connection between their business and the domain name which they're actually seeking to register. But if you look closely at those terms and conditions, there really is intended to be a prohibition on people just registering a domain name when it really has no connection with their business, and to stop people, cyber squatting, sitting on a domain name which is generic and is simply being chosen because somebody somewhere might want to use that at some point. Another aspect of this is that each of the domain name companies now have dispute resolution procedures which are quite detailed and actually very well used. So if somebody is sitting on a domain name to which they're not entitled, you can go to the domain name registry and you can use the various dispute resolution procedures to get that domain name transferred from somebody who's just sitting on it to somebody who has a genuine reason to want to use that domain name.
Yeah, typically in my experience with that guy is that if you own a generic domain name, even if you have that domain just parked with advertising, as long as you're generating income or can demonstrate you're generating income from it, you have as much right to have the domain as somebody else. I think the where it falls into an area of that gets very murky is particularly when it goes into something that's more of a brandable name,
Yes.
or particularly if you've registered a name that is legally a business name or trademark of someone else, then you really have no right to have it at all. But in terms of generic domains, like as an example, I own cardboard.com.au. Now, could someone come along and trademark the word cardboard? Highly unlikely, would you say?
No, look, one of the requirements for a trademark is that it cannot be descriptive of the product. So somebody couldn't register cardboard if they're selling cardboard. That said, if they were offering, in some kind of different service, unrelated cardboard, then yes, perhaps they could register cardboard as a trademark. The thing about trademarks is that the register is divided into various classes of goods and services. So you register your trademark for the class of goods or the class of services, or several of them, in respect of which you're actually trading in. Which means that some people can get the same trademark, but for different goods if there's no relationship between the different goods.
Yeah, I mean, look, I spend a lot of time on the IP Australia website. So while I'm registering domains, checking to see if anyone has trademarked the domain that I'm getting, and I won't go near anything that has been trademarked for that reason.
Yes,
and so most of probably 95% of the names I've got are generic, like cardboard as an example. So yeah, it's interesting. I think you have to be able to demonstrate that you have as much right to have the name as the person who is putting in the complaint. I've only ever had that happen once. That was probably about 10 years ago, and that was I was certainly on the borderline, and that was when I was new to the domain investing game, and I didn't quite understand what was going on. Yes. I said, yeah, that's fair enough, and I handed it over straight away. So you've got to be careful, and it's like everything, do your due diligence before you get involved in anything that is sort of going down this sort of path. And this is where
I think that's important.
And this is where people, they need to come and speak to people like yourself and spend a small amount of money at the start to get good advice, and they may end up engaging you for other things and further advice and further work, but at that initial consultation, it's typically worth its weight in gold, because you don't go and make the stupid mistakes that often people make because they just don't have that upfront information.
I definitely agree with that. It's can be a small investment, but perhaps the best investment you make in your business to actually do things right from the start, and know the environment in which you're operating, and avoid having issues down the line which are going to cost you an awful lot more money to sort out later, rather than trying to do it before the problem arises. Yeah,
and it typically always does cost more later, doesn't it? In most scenarios.
Oh, definitely. Yes. So as soon as you're into a dispute situation, that's where it can get pretty expensive.
Yeah, because you're paying a lawyer by the hour to work on your defence, which
Yes.
So this is where a lot of people, if they, and you've probably seen this happen, if they're a small player in their market and a big player comes along who's got the manpower, the resources, the money, the lawyers to do the work, often the small businesses will just give up and fold because they just can't win in that sense. They may they may have the opportunity to win if they had the right backing and money and lawyers to defend them. So how often do you see that scenario?
Oh, actually quite often, yes. Companies like Amazon are notorious for trying to protect themselves, and in such a way that they really can end up with a smaller company unable to afford the fight, they tend to bulldoze them, and it's not often, or sometimes it's not an even playing field when it comes to the dispute.
No, and then you've got patent trolls. I mean, that's a whole interesting subject, isn't it? People who are, they're just out there registering patents, and then they're going off and suing companies that have something that's similar. Do you have a lot of experience with that?
No, to be honest, I think that's more of an American phenomenon.
Okay.
And I think there's a number of reasons for that. Firstly, Australia, there's a fair bit of patent litigation goes on, but not as much as there would be in the US, for example. And we don't have in Australia contingency fees, which allows a lawyer to take on a case on a contingency basis, which means that the lawyer has a vested interest in the patent litigation. And I think that sometimes drives the litigation. And also in America, they're much more willing to give aggravated or additional damages, which increase the pot of gold, which is then available to the patentee and to the patentee's lawyers. Again, we don't have that so much in Australia. The Australian courts are not inclined to give the sort of damages awards that can happen in America.
Yes, the US definitely wins the gold medal for a litigious society. So they're a bit crazy. Yes. They like to sue anything they can find. I think it seems to get a little bit out of hand. So Brendan, we're getting close to the end of this fascinating chat with Guy. Do you have any other things that you wanted to ask?
Yeah, I'm curious about advertising, Guy. So I don't know how much you know about online advertising, but Google, for example, you can, in the Google search results, you can advertise against, say, searches for a competitor's brand name. You can't mention their name in the ad. Well, in some cases, I've seen people get away with it, but where's the boundary, or where is it getting to kind of, where are you going to get yourself into trouble when it comes to doing that? Because, you have a lot of people who aren't, like, even we're not lawyers, and we manage ad campaigns on behalf of clients. And I don't know about Ed, but I get it fairly regularly, people asking questions about advertising against competitor business names and things like that. So is there a rule or a heuristic that, is the general best practice for that? Or,
sure.
So talk to us about that.
Yeah, look, there's a number of issues involved there involving trademark infringement and misleading or deceptive conduct. But you're right, the case law in Australia has generally evolved such that you can use things like trademarks as a search term. For example, if I'm Toyota and I'm trying to sell my cars, I can use Honda as a search term, so that when people type in Honda, they come to a Toyota advert or to a Toyota website. And that's generally considered okay, as long as you don't use Honda in your actual advert or in your actual website. Mm-hmm. So that's where Australian law has evolved to that position. I say evolved because it's been considered in a few cases, but not really categorically decided. But I think generally people accept that that's the position. But what you can't do, obviously, is represent that your products are somebody else's products, or your services are somebody else's product. That could be an infringement of the trademark. It could also be misleading or deceptive conduct. Misleading or deceptive conduct is a very wide concept and is used for in numerous scenarios. It's the sort of cause of action of last resort, if you like, to try and find something which is misleading or deceptive. But generally speaking, the practice of the use of search terms, as you described it, is not considered misleading. But as soon as you start using the trademark or the name in such a way that you're saying, well, these are my goods and services, when they aren't your goods and services, then that's where you can end up in breach of the act.
Mm-hmm. So essentially, like, basically where you're starting to be slimy or do something that would be considered dodgy by a customer, right? That's effectively what you're saying.
Yeah, look, dodgy can be. There's a thin line between sharp practice, which is perhaps legal, and being dodgy or being misleading. The courts are quite flexible in how they enforce things. If they see dodginess, or perhaps in more legal terms, in bad faith or lack of good faith, then they're more prepared to intervene.
The typical advice that I give my clients is to keep away from it altogether, because it's a bit of a double-edged sword. If you are using your competitors' keyword terms in an ad, to trigger an ad, not actually in the ad copy, then they can do what's to stop them from doing the same. So, give as good as you get ultimately. So that's what will happen. You'll end up getting them using your name to trigger ads. And typically we find that is a bait and switch scenario, because a lot of people, they're getting misled. They're searching on one thing, and then they actually click on the ad and go through to another product page, and they go, hang on, I was looking for, a Toyota Prius, and I ended up with a Honda, whatever. Hang on, this is a bit weird in that scenario. So we typically say to clients, don't do it, because at some stage the law may change and you can't do it. And regardless of what Google is saying, because Google in their terms and conditions, apparently they're okay with using a competitor's keyword term to trigger the ad. But again, it's more of a moral issue that it comes down to. So we say to our clients, look, don't do it. Some of them don't listen to us. We'll say that and say, no, we're going to do it anyway. Well, we've given them the information, so they ultimately, it's their choice. But it is it's a bit of a interesting area at the moment.
Mm. And look, an area which could change, it just needs a case with a particular factual scenario that the courts look at and say, well, that is actually misleading. People are being misled. And you could have the law developing in a different direction. But certainly at the moment, as you describe it, it's not illegal to use somebody else's name in your search terms. Yeah.
So that's, it will be interesting to see where it all ends up. So, but the obviously the condition is seek legal advice. Don't take anything we're saying on this podcast as legal advice. Speak to someone like Guy. That was a bit of a segue for you there, Guy. You need to get that proper advice. We're here just to point you in the right direction and get you thinking about things you may not have thought about before. But certainly when it comes down to protecting your business and your trademarks and intellectual property, you need to go and speak to someone like Guy. So, is there anything you'd like to leave us with, Guy? Because we're sort of at the end of our time now. We'd like to let you get back to doing your work.
Oh, look, I think just something which I mentioned earlier and which Brendan raised as well, about doing due diligence and actually making an informed decision at the beginning of things. So you think about IP, you think about ownership of copyright, like who owns the copyright in the software. You think about, is my app patentable? Is that a possibility that I could pursue? Looking at your various agreements with the various people you're dealing with to make sure that the intellectual property issues are dealt with. Looking at trademarks, looking at the register to see what's there. The IP Australia website is really a very good facility for searching, both for patents and trademarks. So certainly, it's a good place to start at. But if you do the right things at the beginning and make an informed decision and about IP, it's an awful lot better than not thinking about it and then coming a cropper later on when the problems arise.
Yeah, very true. So, Guy, the best way for people to contact you is they can go to the Raise website, and that's spelled WRAYS.com.au. So that's Raise. Guy's email address is guy.provan@raise.com.au, and Provan spelled Provan. We'll put those links in the show notes so people can just click on them there as well. So that's great. I think that is some very, very good information there for people to start down the path of protecting themselves. So thanks again for your time on the show, Guy. Great to have you.
Not a problem. Thanks very much for that, Ed. Brendan.
Thanks, mate.
Thanks, Brendan. And Guy, I'll see you at the next e-group meeting at the start of next month.
Maybe next Tuesday, yes.
Yes, too true. That comes around very quick, doesn't it?
It does.
All right. Thanks, guys. Have a fantastic day.
Okay.
And we'll
thanks for that.
Speak to you soon.
Thanks, guys.
Bye. You've been listening to The Business Marketing Show. You can find us at businessmarketingshow.com on iTunes, SoundCloud, and Stitcher.